Now back to the show. This is The Law Show on CL 650.
We can work it out. We can work it out. Life is very
Welcome back
short.
to The Law Show. It's nice to have you with us this Sunday morning. We're talking wills and estates law with John Lakes and John White from Lakes White LLP in North Vancouver. And we're talking about, among other things, undue influence on this morning's program. And part of getting us to understanding what undue influence is all about, as John Lakes has pointed out, is understanding the issue of competency. You have to be in charge of yourself and able to sign a document and prove that you understand it. But I guess, John White, the question, and this would be something that you probably dealt with on more than a few occasions in court, how competent do you have to be? How razor sharp must you be in order to satisfy the requirements of a will?
Well, I think reality is you don't have to be perfect. You don't have to be as razor sharp as you were in earlier years. You can be competent enough to sign a will even if you're not completely able to manage your other aspects of your affairs in the way that you used to be. Even if you've started to deteriorate a bit, what you have to be able to do is to comprehend out of your own initiative really the essential elements of will making, such as what you're doing, the fact that you are signing a document which gives away your property after you die.
Right.
You got to know that. You have to have an appreciation of what property you're giving away.
Sure.
You have to have some degree of understanding of who would be the obvious people for you to give that property to, such as your spouse, your children in particular. But you don't have to be perfect. There are plenty of cases of people who were, in many aspects of their life, crazy. People who suffered from bizarre delusions about many aspects of their lives. But on the question of, do they understand what their property is, and do they understand they're giving it away when they die, and do they have an understanding of who they should be giving it to or might want to consider giving it to, if they are able to understand those sorts of things, they're generally held to be competent to execute a will. It's not a test of perfection.
Sure. Okay, so that's good clarification, because it kind of left the door open a little bit there in terms of because you've, I suppose, in many cases had to prove competency to one extent or another, haven't you?
Yes, I have, and you need to have those questions in mind when you're going about that task. There are a number of ways you might prove competency. I mean, if the will's properly executed, and there's evidence that the person who wrote the will, or I should say the person who signed the will, had either read the will and understand it, or even just picking up on John's example of someone who doesn't speak English or read English.
Right.
If they've had the will read to them, especially in their own language, and they appear to understand it, and if the will is properly executed with the appropriate witnesses and so forth, the will, or there's a presumption of law which operates that the person who signed a will like that in those circumstances was probably competent.
Sure. Okay.
And that's kind of a shortcut that's often used in court to prove competency or testamentary capacity, which is something you have to prove one way or the other when you're trying to prove a will. But if that doesn't work for you, if you can't prove a will through that shortcut, you still have to be prepared to prove it some other way.
Yeah.
And that can often involve bringing in a medical opinion.
Okay.
Sometimes I can think of a case where we were prepared. We ultimately did prove the will via the shortcut, the presumption. There was simply no evidence that this elderly testator wasn't completely competent, even though she didn't read English. We were prepared to prove that she was competent through an opinion from her doctor, who actually testified in the case. This lady was as sharp as a tack.
Sure. Okay. Fear of intimidation, John Lakes, it seems fairly self-explanatory, but from a wills and estates law perspective, what are we talking about when we're talking about fear of intimidation?
Well, this is where the concern is that the person who signs the will is not acting fully independently. So there's a concern that somebody has a great deal of influence or control over the other person, which then has the person make decisions that more benefit the person rather than the person writing the will. And there's certain things that as a lawyer we have to watch out. So the number one concern would be is normally you see a client by themselves without the other person there. So for example, if a mother comes with her daughter, I'll ask the daughter to leave and I'll meet with the mother alone. If
it's matters of the mother's estate that
well,
maybe
doing
the daughter,
a will,
right?
And quite frankly, if the daughter won't leave, then probably I won't see the person, because that's the number one warning sign, is that the daughter may have control over the mother and wants to make sure the mother does what the daughter wants the mother to do rather than what the mother may or may not want to do. So the issue of control, there's other things when you start interviewing the people, you ask about things like isolation, whether that person, the will maker, has been cut off from the rest of the family by this person.
Right.
You have to ask questions and observe the situation, such as whether there seems to be some dependency, whether there's some sort of confusion, there's memory problems, there may be some signs of depression, delusions. And the delusions can be important because they may have an opinion about their other child, which may not be based on their experience, but more from what their other child's told them about the
hearsay.
So they think
right.
This child may be a nudist, or they may think this child goes around and robs liquor stores, and it may be all untrue, but
Sure.
But based on the fact that they've been isolated from the other child. Or the old prodigal son in the Bible, the guy who comes back and the parents so happy to see them, and all of a sudden they find they're told all these things that are not true. Drug and alcohol dependency is a big issue, because sometimes what happens, you might have somebody who's got an alcohol issue,
Right.
and the only child they're dealing with are the ones who are willing to supply them with alcohol. And the reason they're not seeing the other two kids is the kids are trying to cut them off alcohol.
Right.
So it's
And so the enabler child in that bunch is going to be the one most likely to benefit,
Of course.
from the outcome of the will. And that, as the lawyer, when you see this person staggers into your office
Yeah.
and wants to change the terms and conditions of the will to give everything to the kid who's still okaying the booze, then your reaction, again, you rely on your gut a lot here, don't you, John?
Well, you
with this
also,
stuff?
the simplest word to say is no.
Right.
And it's a hard thing to tell someone you're not going to act for them. And it doesn't happen very often, but you never regret the decision, but we are quite often the gatekeeper, because we're the person. And of course the problem we do have, though, is because there's this whole issue of solicitor-client privilege. So we can't turn around and tell the other child, well, this is happening, because we have a certain degree of confidence.
Sure, of course.
So we may be able to contact the police if we feel that it's got to the point of a criminal matter, but so that's sometimes the problem where lawyers are getting the bad name, is we see this and we refuse to do it, but we can't say anything about it, which is another issue.
John White, when we're talking about fear of intimidation in the same context as undue influence, it strikes me as that they're almost one and the same, but not quite, right?
Well, I suppose fear of intimidation is a subspecies of undue influence.
Right.
I mean, I look at these cases, or when they come to me, I'm looking at them through the rearview mirror. The testator's already died. There's a battle over whether the will is valid, and I'm now having to address the question as to whether this person who's now deceased and can't speak for themselves was unduly influenced in the writing of the will or not.
Okay.
And really, the question it always comes down to, and the classic test really is on the evidence. If you had the person in court, the testator in court,
The will maker.
the will maker, as we
Right,
now
right.
call them, in
Right.
court, would they say something like, well, this isn't what I wanted to do, but I had to do it?
Ah.
And that formulation of that test, maybe in a little more elaborate language, has been around since the 19th century, and it's still the case today. And so, we talk about fear of intimidation. That's a great example of a situation where, if it's proven, the will maker probably would say, well, I didn't want to structure my will the way I did, but I had to do it. And they might complete that sentence by saying, because I was intimidated by my daughter, or I feared what my son would do if I did other than what he told me to do, or something like that.
Right. John Lakes, does the exertion of undue influence typically come from inside the family, or is it an outside party?
Oh, it's usually within the family. I mean, it's sometimes there's 50 years of history, and perhaps the person you're seeing may not have been the nicest parent either. So maybe the kids have grown up fighting off each other anyway. And so it's not that often there are strangers. Sometimes there are, but it's usually within children or nieces or nephews, or because they know the family history. They know all the strengths and weaknesses of the will maker. They know what will push their buttons.
Right.
Maybe there's a religious issue. Maybe there's something that happened many, many years ago, or someone wrecked a car, or things like that, where sometimes these things are festering for a family for 30 or 40 years.
Right.
And one child will bring this back to the surface, particularly if, let's say, you've had a husband-wife, the husband's died, the wife's quite vulnerable, she's quite lonely.
Mm-hmm.
Maybe the son lives in Toronto, is very busy, or maybe he's got a Down syndrome child, so he doesn't have the time for mom. So, the daughter will say, oh, well, Johnny's always been like that.
Right.
So it's families are pretty destructive to each other, especially now with real estate values being $1 million, $2 million. There's
Sure.
a lot more to fight over. So, I mean, you don't very often come onto a total stranger being involved. It does happen, but not very frequently.
Okay. And the other example that we hear of John White, the guy who goes to court the most, is second families. There's a first family, maybe one of the spouses has passed on, maybe there's been a divorce. And so there's now a second family. There's an older set of adult children and maybe their mother. And then there's the second younger family with much younger children and a younger wife. And that, of course, when the will is read and explained, not everyone is usually happy. Is that where the bulk of the conflict comes from between those two family levels?
Well, I wouldn't say that there's any particular source of the bulk of conflict. Families, as was famously said, unhappy families are each unhappy in their own way. But that certainly is one fruitful source of conflict. And it happens all the time. And there is often tension between, if you like, the first family and the second family.
Right, absolutely.
Quite often it's unresolved conflict over how the second family came to be in the first place.
Mm-hmm.
And depending on what's in the will or how the will maker has structured his or her affairs, people can find lots of reason to fight over it. But in terms of undue influence, just because conflict exists, or the potential for conflict exists,
Undue influence isn't automatic, is it?
It's far from automatic, although it's easier to prove now than it once was. Looking at these cases through the rearview mirror and wondering, well, how would I ever establish that there was undue influence, even where I look at a case and think, well, that's an odd will. I wonder how that came to be, and it looks suspicious to me, perhaps. Used to be that the proof of undue influence was put squarely on the person who was alleging undue influence.
Right.
It was hard to prove, and if you alleged it and you didn't have the evidence to back it up, you could be taking a real risk in that the court might actually penalize you in court costs for making such an unsavory allegation that you couldn't back up.
As we discuss and go forward with our discussion of undue influence, John Lakes and John White have brought several actual decisions and cases, precedents from Supreme Court of British Columbia. And we'll take a look at some of those. We'll apply the theory to real people. when we continue on The Law Show with John Lakes and John White. Online, by the way, at lakeswhite.com. And let me spell it for you because it's a little different. Lakes, pretty obvious, L-A-K-E-S. White is W-H-Y-T-E. So lakeswhite.com. Check it out while we do this quick commercial timeout.
There's more of the show still ahead. This is The Law Show on CL 650.